One of the most difficult aspects of the job of judging is to impose an appropriate, just, and fair sentence. It's never an easy or fun responsibility. It's even more complicated when a judge is confronted with discretionary choices. In many of our cases, the terms are set in stone and the judge has no discretion. But when a judge is called upon to exercise discretion, it's a very significant responsibility. And that responsibility is compounded in a case such as this, where neither party is saying that Dr. Murray acted intentionally in being responsible for the death of the decedent, Michael Jackson. Even the people just acknowledged that Dr. Murray did not intend for Mr. Jackson to die. So the court is called upon to utilize its sense of fairness and decency, as well as various factors it has gained over the years of its experience, in fashion.
Right away, the judge draws a powerful line in the sand here. This isn't about painting Dr. Murray as a monster or a hero. It's about accountability. And that's a huge legal distinction. Courts aren't supposed to rule with emotion, but in a case tied to someone as globally iconic as Michael Jackson, keeping emotion out of the courtroom is almost impossible.
What it believes is an appropriate sentence in this case. There are those who feel that Dr. Murray is a saint. There are those who feel Dr. Murray is the devil. He's neither. He's a human being. He stands convicted of the death of another human being. And that death is predicated not on simple civil negligence, but on criminal negligence. And it's important for the court to realize that that is the appropriate standard. The standard of criminal or gross negligence, and the fact that a jury of 12 people from remarkably different backgrounds and life experiences concluded unanimously and beyond a reasonable doubt that Dr. Murray had, with criminal negligence, caused the death of Michael Jackson. It's important to emphasize the standard of criminal negligence found by this jury beyond a reasonable doubt, because some may feel this was a medical malpractice case. It wasn't. It was and is a criminal homicide case. And this jury found beyond a reasonable doubt that the defendant, with criminal negligence, caused the death of Michael Jackson. And criminal negligence is defined as follows. Criminal negligence involves more than ordinary carelessness, inattention, or mistake in judgment. A person acts or fails to perform a legal duty with criminal negligence when, 1, he or she acts or fails to perform a legal duty in a reckless way that creates a high risk of death or great bodily injury. And 2, a reasonable person would have known that acting or failing to perform a legal duty in that way.
Microphone hash. This is the moment the judge explains the heart of the entire conviction. Criminal negligence. Not a simple mistake. Not bad luck. The prosecution had to prove that Dr. Murray's actions were so reckless that any reasonable person would have recognized the danger. That's why this case crossed the line from medical malpractice into criminal homicide.
Would create such a risk. A person acts with criminal negligence when the way he or she acts is so different from the way an ordinarily careful person would act in the same situation that his or her act amounts to disregard for human life or indifference to the consequences of that act. It's important to remember and focus on those terms and not to treat them cavalierly, as some might, by saying, oh, well, it just happened. And, oh, well, if it weren't for Dr. Murray, someone else may have been involved. I categorically disassociate myself from those types of statements. This is not a question about what might have happened or what if someone else had been involved, if not for Dr. Murray. That is an insult to the medical profession. The fact is that Michael Jackson died because of the actions of and the failures to perform legal duties on the part of Dr. Murray. Not some other medical doctor, and also not exclusively because of Michael Jackson. I accept Mr. Chernoff's invitation to read the whole book, and I have. I've been impressed by the submissions from family and friends and associates of Dr. Murray. It is a book of Dr. Murray's life, but I've also read the book of Michael Jackson's life, not isolated chapters from either. Regrettably, as far as Dr. Murray is concerned, the most significant chapter as it relates to this case is the chapter involving the treatment or lack of treatment of Michael Jackson. And Michael Jackson died not because of an isolated, one-off occurrence or incident. He died because of a totality of circumstances which are directly attributable to Dr. Murray. Not some mistake or some accident in the early morning hours of June 25th, 2009, but because of a series of decisions that Dr. Murray made which jeopardized his patient, which violated his obligations to his patient and the essence of his Hippocratic oath. Those violations overcome the other aspects of Dr. Murray's treatment of other patients and the good deeds he may have done before that time. Dr. Murray created a set of circumstances and became involved in a cycle of horrible medicine. The practice of propofol for medicine madness, which violated his sworn obligation for money, fame, prestige, and whatever else may have occurred. So I don't look to one isolated incident in terms of the misdeeds of Dr. Murray or the deeds of Dr. Murray. But insofar as this case is concerned, Dr. Murray engaged in a recurring, continuous pattern of deceit, of lies, and regrettably...
Microphone hash listen to how the judge keeps repeating words like lies, deceit, and cover up. That repetition is intentional. He's building a narrative for the sentence, not just that mistakes were made, but that there was a sustained pattern of dishonesty. And in sentencing hearings, judges often focus just as much on conduct after the crime as the crime itself.
That pattern was to assist Dr. Murray. It is almost inconceivable that Dr. Murray would have persisted in this pattern over such an extensive period of time. the lies, the deceit began and continued, as we heard for 6 weeks' worth of testimony, to build up an absolutely astounding set of circumstances. The lies from the inception of his medical relationship at the Holmby Hills residence in terms of ordering propofol in staggering quantities, unprecedented quantities. The lies to the pharmacy and to the pharmacist. The sophisticated, intentional deception in that regard. The lies and repeated deception to those associated with Mr. Jackson, whether it be members of the staff and also members of the production team, AEG, and Mr. Jackson's personal and professional associates. The continuing series of lies to Michael Jackson's security and staff personnel at a critical point in time. The unconscionable lies to healthcare providers, lifesavers, paramedics, and medical personnel at UCLA, which were not designed to help his patient, quite the contrary, which were designed to deceive and give Dr. Murray a way out. The efforts on the part of Dr. Murray to subvert the process by attempting to destroy evidence. Subsequent efforts to cover up by distortions and lies to law enforcement. If one looks to the crime of involuntary manslaughter in a vacuum, one can say this may be something that went terribly wrong, and it's tragic. But it's so critically important not to have a superficial gut reaction to what happened in this case, but to look at the totality of circumstances in terms of the long-standing failure of character on the part of Dr. Murray to serve his patient. And when one does that, one can't help but be offended by the circumstances in this case. Of everything I heard and saw during the course of the trial, one aspect of the evidence stands out the most, and that is the surreptitious recording of Michael Jackson by his trusted doctor. And I have repeatedly asked myself, why did this happen, and for what reason? And I can speculate and surmise that there might have been some justifiable reason, some benefit to Michael Jackson. That would be an entirely unreasonable conclusion. That tape recording was Dr. Murray's insurance policy. It was designed to record his patient.
Microphone hash that secretly recorded audio of Michael Jackson became one of the most disturbing parts of this entire case. The judge isn't just talking about evidence here, he's talking about betrayal. A doctor-patient relationship is built on trust, and the court clearly saw this recording as a violation that went far beyond medicine.
Surreptitiously, at that patient's most vulnerable point. I can't even imagine that happening to any of us because of the horrific violation of trust. And I can't help but wonder that if there had been some conflict between Michael Jackson and Dr. Murray at a later point in time in their relationship, what value would be placed on that tape recording? if the choice were to release that tape recording to a media organization to be used against Michael Jackson. And regrettably, that failure of character was compounded by later actions on the part of Dr. Murray, each of which amounted to a betrayal of trust and confidence and a clear violation of the doctor-patient relationship and an undermining of the phenomenal role and responsibility that healthcare personnel, doctors, nurses, paramedics, healthcare aides, perform in our society. We revere medical doctors, and we should, because they work diligently and they serve and they make sacrifices to keep us well. And unquestionably, Dr. Murray did that. But at some point, things went terribly wrong for Dr. Murray, and when he had an opportunity, he didn't get out. He stayed in, and he got deeper and deeper in trouble, and he betrayed the very oaths and tenets of his medical profession. So I do look to the totality of circumstances, and when I look to the totality of circumstances, and when I look to the whole book, the book of Dr. Murray's life, I also look to the chapter that disturbs me most, and that's the chapter to which I've referred. I can't say that my opinion changed after I became aware of the production involving Dr. Murray after the jury verdict in this case. When Dr. Murray says, "I don't feel guilty," that's what he says. Mr. Chernoff acknowledges candidly that there's fault here, but you're not hearing it from Dr. Murray. You didn't hear it at the time that Dr. Murray interacted with the security staff and the staff at the Holmby Hills property. You didn't hear it from Dr. Murray when he encountered members of the paramedics squad, paramedics Seneff and Blunt. You certainly didn't hear it when Dr. Murray encountered Doctors Cooper and Nguyen, who were on a life-saving mission. You didn't hear it when Dr. Murray talked to the detectives of LAPD, and you certainly didn't hear it during Dr. Murray's interview in this faux documentary, faux reality production, wherein Dr. Murray says, "I don't feel guilty. I wasn't reckless. I didn't tell them about propofol because they never asked the question, and it wasn't important." And where Dr. Murray at that point says he feels betrayed and entrapped by Michael Jackson. Yipes! Talk about blaming the victim. Not only isn't there any remorse, there's umbrage and outrage on the part of Dr. Murray against the decedent, without any indication of the slightest involvement in this case. To hear Dr. Murray say it, Dr. Murray was just a bystander who sort of came upon a scene and was put in this situation because of everybody else's actions other than himself, whether it be members of the family, whether it be members of AEG, whether it be Mr. Jackson or anybody else. Those are factors which cause me tremendous concern, because the essence of probation is...
Microphone hash. This section is absolutely devastating for the defense. The judge is basically saying, how can I grant probation to someone who refuses to admit wrongdoing? In criminal sentencing, remorse matters a lot, and according to the court, Dr. Murray showed none. Instead, the judge sees deflection, blame shifting, and zero rehabilitation.
A recognition that someone may have done something wrong, some responsibility, some remorse. why give probation to someone who is offended by the whole idea that that person is even before the court? You can't have probation when there isn't an acknowledgement of rehabilitation and responsibility. And regrettably, Dr. Murray doesn't have any of them. Dr. Murray certainly is statutorily eligible for probation. I looked valiantly for efforts to satisfy myself that while Dr. Murray was legally eligible for probation, he was suitable for probation. And I really didn't become convinced I could find any. Dr. Murray is eligible for probation. The court declines to grant probation in this case for a host of reasons. And in making that decision, I acknowledge that Dr. Murray has, throughout his 58 years, provided services to the community and has helped many individuals. But I also acknowledge that he unquestionably violated the trust and confidence of his patient, Mr. Jackson, on a repeated nightly basis. Michael Jackson, as a patient, was vulnerable because Dr. Murray put Mr. Jackson in a position where Dr. Murray was responsible for the very life of Mr. Jackson. Dr. Murray engaged in a sophisticated scheme to obtain propofol through insidious means by lying to the pharmacist, to concoct a story, by not keeping records, and by allowing his personal life to interfere with his professional responsibilities. At the very time that people are depending upon Dr. Murray to be candid with them regarding Mr. Jackson's medical condition, Dr. Murray is lying. He's lying to the AEG people, he's lying to Mr. Ortega, he's lying to the insurance carrier, and anybody else he can, and he's engaged in personal matters while he should be paying attention to his patient. Anybody who takes an objective view of what was going on here has to come to an ineluctable conclusion that Dr. Murray abandoned his patient. And this is not a simple one-off occurrence. This is an unacceptable, egregious series of departures from the appropriate standard of care, which undermine the physician-patient relationship and which are a disgrace to the medical profession. An honorable profession which bears the blot, the scourge of what happened here. So we're not talking about a single isolated mistake. What we're talking about is a gross continuing deviation. So for those factors, the court makes a determination that Dr. Murray is not a suitable candidate for a grant of probation. The request for probation under the rules of court is denied. The question then becomes, what is the appropriate period of incarceration? The court has many options, including hybrid-type sentences as authorized by the Realignment Act of 2011, and straight sentencing. This court does not have the legal authority to actually send and imprison Dr. Murray in state prison. I do not have that legal authority, and I certainly am going to follow the law in that regard. The legislature of this state signed a Realignment Act that declares certain offenses, while felonies, not to be served in state prison, and involuntary manslaughter is one of those. I do not have that legal authority. I must determine the appropriate sentence, and in making that determination, the court is guided by a triad of possible sentences that the court can impose: 2, 3, or 4 years. The court no longer has to weigh what are called aggravating circumstances or factors versus mitigating circumstances or factors, but has to give a statement of reasons. The court has determined that the appropriate term is the high term of 4 years imprisonment. I do so because, once again, I find that Dr. Murray abandoned his patient who was trusting him. His patient was vulnerable under those circumstances, having been administered potentially dangerous drugs by his medical provider. Dr. Murray's course of conduct extended over a period of time. Dr. Murray repeatedly lied, engaged in deceitful misconduct, and endeavored to cover up his transgressions. He violated the trust of the medical community, of his colleagues, and of his patient. And he has absolutely no sense of remorse, absolutely no sense of fault, and is and remains dangerous. It's easy to say, oh, well, Dr. Murray's a medical doctor. He's a smart, sophisticated man. He does not have a criminal history. He may not be licensed to practice medicine in the future, although that has nothing to do with me. I have no authority over that. The fact remains, Dr. Murray is offended by that patient dying. And I don't have any idea what will prompt Dr. Murray to do or not do something in the future that may be dangerous to a patient. If he does practice medicine in the United States or even elsewhere, I think Dr. Murray is so reckless, based upon the law and the definition of criminal negligence that I read, and everything that I heard and saw in this case, and Dr. Murray's subsequent conduct, that I believe he's a danger to the community. I've taken into account all of the factors. I've stated my reasons, and those reasons, the nature and character of the offense, distinguish this charge of involuntary manslaughter in this case, and this conviction of involuntary in this case, from other cases involving involuntary manslaughter. And there's a fundamental aspect of the criminal justice system which is involved here, and that is the fundamental aspect of punishment. It should be made very clear that experimental medicine is not going to be tolerated. And Mr. Jackson was an experiment. The fact that he participated in it does not excuse or lessen the blame of Dr. Murray, who simply could have walked away and said no, as countless others did. Dr. Murray was intrigued by the prospect, and he engaged in this money for medicine madness that is simply not going to be tolerated by me.
Microphone hash, and there it is. The final hammer drops. 4 years. But notice something important. The judge says this sentence is also meant to send a message. Courts call that deterrence, punishing one defendant in a way that warns others not to repeat the same behavior. In the judge's eyes, this wasn't just about Michael Jackson anymore. It was about protecting future patients from what he called money for medicine madness.
So as to sentencing in this case, the request for probation is denied. The court imposes the high term of 4 years imprisonment in this case. Pursuant to the Realignment Act of 2011 and the provisions of Penal Code Section 1170, Subdivision H, that 4-year sentence is to be served in the Los Angeles County Jail under the care, supervision, and direction of the Los Angeles County Sheriff. Dr. Murray is to pay an $800 restitution fine pursuant to the provisions of Penal Code Section 1202.4 and the statutory scheme therein, a $30 court security fee pursuant to Penal Code Section 1465.8, Subdivision A, Paragraph 1, and a $40 criminal conviction assessment pursuant to Government Code Section 70373. As a convicted felon, Dr. Murray is ordered to provide specimens and samples of blood, saliva, fingerprints, and palm prints for law enforcement investigative purposes and the state DNA data bank, and his willful refusal to provide any such specimens and samples is a separate crime. I am concerned about the restitution requests in this case. I sense that the people and the defense share those concerns. It's not often that courts are called upon to order restitution in the sum of $101,821,871.65 based upon a 3-line statement in an email and electronic mail. So the court is going to order Dr. Murray to pay appropriate restitution to the estate of Michael Jackson and to the children and other family of Michael Jackson, pursuant to the provisions of Penal Code Section 1202.4 and the case of People v. Lunsford, Lunsford, at 67 Calap 4th 901, in the amount and manner as determined by this court at a later restitution hearing, where the court can be provided by the people through Mr. Weitzman and through anybody else with more detailed information. Now, Mr. Walgren, as you know, Mr. Weitzman indicated that the above information is a combination of monies actually spent. Well, I'd like to see it. And, quote, some very sophisticated projections on the anticipated revenue stream from a concert that had been sold out before Mr. Jackson's death, end quote. I believe we've discussed during various motions in this case issues involving detailed financial records. Certainly the defense and the people have been interested in those types of records for the length of this litigation. But before this court can order and will order any such restitution, I need much more detailed information. And that may involve strategic choices on the part of the Jackson family and on the part of the estate, whether and under what circumstances those figures are to be released. But I'm not going to order restitution at this juncture based upon those conclusory statements. If and when the court makes a determination, the court can order that restitution be paid through the State Office of Revenue Reimbursement. I'm happy to set this case at a later point in time for a determination of more detailed restitution amounts. How many days in custody has Dr. Murray served, Mr. Gorgian? You're checking? Because I want to provide appropriate credits.
23 days actual.
Dr. Murray is entitled to 23 days of actual custody credits plus good time, work time credits of that exact same number, 23 days. So toward the 4-year sentence in this case, Dr. Murray received total credits of 46 days in custody. I invite counsel to suggest another date when this matter can be calendared for a determination of appropriate restitution, unless you want to simply defer it and notify me in the future as to a date. That's up to you.
Due to the complexity of it and the number of people I'll need to speak with, Your Honor, maybe it's wiser to simply defer it, and then we'll notify the court after I speak with defense counsel and the estate representatives as well as the family.
All right. Please be aware of 120 days. I'd like to address this within that 120-day time period. Let me ask you, before I advise Dr. Murray of his appellate rights, are there any additional questions, comments, suggestions, etc., on behalf of the people, Mr. Waldron?
No, only falling back to the restitution issue, if the court thinks it's better to maybe just set a date with the understanding that we'll be working toward that goal, maybe sometime in mid-January or...
I'm fine with that, too. Mr. Murray, I don't know the defense position.
We're opposed to setting a date in January. We'd like to get this resolved quickly.
Well, do you want to stipulate to restitution of $101 million, $821,871.65?
Are you giving me exactly two options, January or $100 million?
No.
So then I guess I'll...
No, it's important that...
next week, 2 weeks from now, something like that?
Well, I'm not so sure that's all that realistic. I always can set it on a date and vacate the date, but I think putting it over for a week or two is not going to accomplish much in view of what I would think would be a lot of financial consideration here. You know, I don't see that time frame as being unreasonable if there are facts and figures which have to be gathered.
Do we need to drag Dr. Murray in from jail after that?
One need not drag in anybody. Dr. Murray can waive his appearance.
I appreciate that.
You can speak to Dr. Murray about that. You know, I'm certainly sensitive to that, too. I don't want to drag anybody in here unnecessarily. Counselor conferring with Dr. Murray.
Dr. Murray will waive his personal
Dr. Murray, you have a right to be present during any proceedings in which I make a determination of whether I'm going to order any restitution in this case, and if so, the amount. Do you understand that right, sir?
Yes.
Do you give up that right and agree that your interests can be represented by those of counsel?
Yes.
Counsel join in the waiver, Mr. Chernow?
Yes, sir.
There's an express and explicit, knowing and intelligent, free and voluntary waiver by Dr. Murray of his right to be personally present. So what date would you like to pick in January?
Can I reach back real quick, get my calendar?
Yes, please.
Week of the 23rd, Your Honor, if that's agreeable with the court and counsel.
Well, it actually have to be on the 23rd because I've got a must-go case starting the 24th. That has been a must-go case which has been must-go during the course of this trial. And finally, that case is a must-go. So if Monday the 23rd is okay.
That's fine, Judge. 23rd of January.
Mr. Walger? That okay?
That's fine, Your Honor. Thank you.
All right. Further proceedings regarding restitution are set Monday, 23 January 2012, 8:30 a.m. in this department without the presence of Dr. Murray. With that in mind, is there anything else that I should address before I advise Dr. Murray of his appellate rights, Mr. Walgren?
No, thank you, Your Honor.
Mr. Chernow?
No, Judge.
Thank you. Dr. Murray, you have an absolute right to appeal the guilty verdict in this case, the sentence, and the judgment of conviction. In order to do that, sir, you must file a timely notice of appeal with the court clerk within 60 days of today's date. That's a document in which you indicate that you wish to appeal this judgment in this case. But you got to do it within 60 days. Do you understand that you have a right to appeal, sir?
Yes.
And do you understand how that is done? By filing the document?
I understand the timeline. I don't understand
the timeline, and it's a document which, Mr. Gorgian, I would gather you're going to be submitting that today?
Sure.
Mr. Gorgian? You're going to be submitting it?
Today
or within the next couple of days?
Yes.
Mr. Gorgian will do that, but it's important that you understand that's the way it gets done. All right, Dr. Murray is remanded to the care and custody of the Los Angeles sheriff in this case to begin his sentence. At this time, proceedings with regard to Dr. Murray are concluded. We're going to take a very brief recess, and then I'll be addressing the issue of further proceedings as regards Matt Alford in just about 10 minutes. Thank you.